Hello everyone, welcome to Analog IAS. In this video series, we'll be continuing our discussion on the Supreme Court of India. In the last video, we have discussed about the appointment and other provisions of the Supreme Court. In this video, we'll be first discussing about the removal process of the judges of the Supreme Court. And the procedure is not such explicitly mentioned in the Constitution. Therefore, Parliament through an act has regulated the procedure for the removal of judges. That is, through the enactment of the Judges Inquiry Act of 1968, the procedure is guided, according to which a removal motion needs to be signed by at least 100 members if the motion is presented in Lok Sabha or 50 members if the motion is presented in the Rajya Sabha for its initial approval. After it is been approved by these members, then the Speaker or the Chairman may admit or may not admit the motion. And if it is admitted, then the Speaker or the Chairman needs to constitute a 3-member committee to investigate into the charges. The 3 members are the Chief Justice of India or the senior-most judge of the Supreme Court and the Chief Justice of one of the High Court and a distinguished jurist. These people decide upon the charges that are framed against the judge. That is, the judge can only be removed only on the 2 grounds, that is, proved misbehavior or incapacity. And once the committee comes to the conclusion that there has been a breach of proved misbehavior or incapacity on the part of the judges, they'll recommend the same to the Speaker or the Chairman. Then the motion is taken up in each house where the removal process needs to be signed by a special majority. That is, half of the total membership of the house plus 2/3 of the members present and voting. That is, if the motion is passed in both Lok Sabha and the Rajya Sabha, then the President is entitled to remove the judge from the Supreme Court. So far, no judge has been removed from the Supreme Court except in one case where Mr. Justice V. Ramaswamy of the Supreme Court has been impeached, where the committee has found that he has been guilty of misbehavior, but the motion could not be carried further because it has been defeated in the Lok Sabha itself. The salaries and allowances of the judges of the Supreme Court are determined from time to time by the Parliament, and they are charged on the Consolidated Fund of India. That is, they become a part of non-votable budget. And the next is the provision for the acting Chief Justice. The President may appoint any judge of the Supreme Court as acting Chief Justice if the office of the Chief Justice of India is vacant, or the Chief Justice of India is temporarily absent, or if he is unable to perform the duties of his office due to illness or anything else. The next is the ad hoc judge. That is, the ad hoc judge is appointed by the Chief Justice of India with the prior permission of the President when there is a lack of quorum on the permanent judges of the Supreme Court. The next is the concept of retired judges, where the Chief Justice of India can request a retired judge of the Supreme Court or the retired judge of a High Court who is eligible to become a judge of a Supreme Court to act as a judge of the Supreme Court for a temporary period to clear the vacancies or to maintain the quorum in the Supreme Court. Now let us solve this question. Consider the following statement. Salaries of Supreme Court judges are votable in the Parliament. Oath to the judges of Supreme Court is administered by the President only. The correct answer is D, none. As we have discussed that the salaries are charged on the Consolidated Fund of India, therefore they become non-votable. While the oath of the judges is given generally by the President, but he is not the only one. The President can delegate this work to some other person to administer oath to the judges of the Supreme Court. Therefore, the correct answer is D, none. Thank you.